The passage of property upon death requires careful planning, which is why farmers often include a revocable trust in their estate plan. However, confusion can arise over tax filing obligations when the grantor dies. Roger McEowen with the Washburn School of Law joins us now with some guidance in today's Rural Money segment. Roger, appreciate you being with us. Can you give us a recap of the benefits of using a revocable trust in your estate plan?
Sure. Good to be with you today, Tammy. Well, I think probably the two primary benefits that most people would cite would be that it is a private document. It's not filed of public record like a will is. And so it's not easily searchable by people to find out what the property was that you had and who got it. And then the second thing, well, maybe three. The second one I'd say is there can be cost savings post-death. It does cost a little bit more up front compared to a will to create it, but compared to probate costs, particularly in states such as California and New York, there can be some savings on the back end. And then third, if you have farmland in more than one state, by putting the property titles in a trust, you can avoid having a probate, if you had a will, in each of those states where you had that farmland or other property. So those are probably the big benefits of a trust.
So what are some of the income tax impacts of a revocable trust when the grantor dies?
Well, when there's a death of the grantor, the trust is going to have to obtain a taxpayer ID number if it didn't already have one pre-death. And even if it did obtain one during the grantor's lifetime, it's going to have another one post-death. So there's going to have to be communication with local FSA office on that to make sure they understand the entity then that they're dealing with. Also, the trustee is going to have to establish new accounts for the trust with banks and other financial institutions with which the trust does business.
Now, are there any techniques that can help simplify tax filings after the grantor dies?
Well, there's one. It's pretty technical, but basically an election can be made under the tax code for certain types of revocable trusts that will have the effect of treating the trust as part of the estate. So we can combine those two entities together for tax purposes, and that can reduce the number of separate income tax returns that will have to be filed after the grantor dies. And that's an irrevocable election once it's made, and it's made by means of IRS Form 8855.
Lots of questions there. That's Roger McEowen with the Washburn School of Law. Appreciate you helping us out and make that a lot clearer for us. Appreciate you joining us.